and see what the wisdom of the crowd is. You might fill out the poll. It's entirely anonymous, and we'll pop up the results shortly. For those of you who don't know me, my name is Declan Black. I'm the current managing partner of Mason, Hayes & Curran. I'm delighted to be chairing today's event. And it's our traditional 2-hour regulatory session required for all lawyers for their CPD, but also good to know. So we're at 430 participants at the moment. This is always a popular session. In the good old days, we used to fill out the Shelburne and I think the marker and provide refreshments. But today, all we can do in terms of formality is I decided to wear a tie because that's very rare on Zoom, and some of our speakers are following suit. So we're now up at 470 and still rising. So I'm just going to give it another minute, but please do complete the survey. What's your biggest challenge in 2021? Or what was your biggest challenge in 2021? I'll be interested to see if inadequate support from external lawyers tops the table. Of course, if that's so, I'm hoping it wasn't Mason, Hayes & Curran. Number 2, questions 2, 3, and 4 are very regulatory focused. Lawyers are more honest and ethical than other professionals. A controversial statement that I have heard. Some people agree with that, some people will disagree. Third question, lawyers should face regulatory sanction for lapses outside of their professional role. So for example, you would think that if a lawyer was found guilty of a criminal offense, it would be appropriate for there to be a regulatory sanction. But what if a lawyer failed to correct the waiter in a restaurant who had undercharged them? These are issues which, in fact, some regulatory authorities consider worthy of intervention, particularly, and it's just interesting to see what people think about that statement. And then the fourth and final question in the survey, solicitors should always be struck off the roll, spelled wrong, I apologize, ROLL it should be, for any misappropriation of client money. Do you agree or disagree, and to what extent? Okay, so we're holding steady at 549 attendees. So maybe we'll just pop up the results of the poll and see where we are with that. Wow, a clear winner. Loss of teamwork due to working from home. Too much work for in-house resources. That's good news for external law firms. Unreasonable client expectations. Very few people think external lawyers have been inadequate, and lack of job satisfaction in at 9%. Okay, we got 315 voters. Okay, let's see about the second question. If we can scrolling down. Lawyers are more honest and ethical. 37, and if you add in the agrees, we're up to 87%. Very positive self-regard. Good to see. And looking then, so sorry, I've gone too far. I haven't actually called that out right on my screen. So, in fact, the agreement with that statement is at 57%, neutral 38%. Should face regulatory sanction for very, very evenly balanced. 30% agree, 31% disagree, 25% in the neutral zone. Always struck off for misappropriation of client money. Very high levels of agreement, which one would expect. Okay, thank you everyone for engaging in the poll. It's always interesting to see what people will say. We're now up at 580 participants. which is a tremendous turnout. So I'm delighted to introduce our first speakers who will take us through the first hour of the session. And they are two stalwarts of MHC, Neil Michel, a partner, and Paul Egan, and now a consultant, but for 3 decades a partner in MHC. There is very little that they do not know about life in the law and I think the regulation of lawyers. Paul is currently a council member of the Law Society, just having been re-elected. Neil has focused on regulatory matters, not just in the legal profession, but across a range of professional disciplines for many years. And the topic they are going to talk about amongst themselves is practicing certificates. It's an odd topic at first glance, but actually it touches a lot of issues. The requirement to have them, what happens if you're working outside the jurisdiction, what is the necessity for an in-house lawyer to have a practicing certificate? Do you need a practicing certificate to maintain privilege? And what are the consequences of not having practicing certificates? So the way they're going to do this is, I think there'll be a short piece by each of them, and then they'll discuss and tease out some of the issues between themselves and then leave some time for Q&A. So that will be, take us up to just close to 1 o'clock, and then I'll come back to introduce the second speaker. So Paul and Neil, thank you very much for your time, and we'll listen to you now.
Thanks, Declan. Good afternoon, everybody. I thought what would be a good idea to do would be to set the scene and to provide some information on the makeup of the legal profession in Ireland and indeed the demography among solicitors. And by legal profession, we're talking about solicitors regulated by the Law Society and the Legal Services Regulatory Authority, barristers regulated by the Bar Council and the Legal Services Regulatory Authority, and notaries regulated by the Faculty of Notaries. We come then to look at the profile of solicitors in Ireland. On the role of solicitors, these are people who have been admitted as solicitors. There are about 20,000 on the roll, and these would include solicitors with practicing certificates, retired solicitors, solicitors who for one reason or another don't have practicing certificates, and of course those who do. At the last count, there were in fact 11,761, but on all of these figures I've decided to try and round them and make them approximate so as to give a general idea. There are 11,750 solicitors holding practicing certificates. There are a further 300 who hold a different kind of certificate, which is a certificate of attestation given to solicitors on the roll in Ireland, practicing overseas under other jurisdictions, but attesting to their admission in Ireland. And in some jurisdictions, this is a prerequisite to getting a local practicing certificate. And then among the 20,000, there are over 4,500 solicitors from England and Wales who have been admitted to the role of solicitors since the Brexit vote 4 or 5 years ago. So if we just move to the next slide, there is just another statistic. When you're a solicitor, you're not obliged to be a member of the Law Society. There are a number of solicitors with practicing certificates, a small number who've chosen not to become members of the Law Society. It's €85 a year that solicitors pay in order to become a member, and membership gives an entitlement, for example, to use the library and so forth, and other facilities in Blackhall Place and at the forecourts. And then there are a number of retired solicitors who decided to keep up their membership after they left. So they're the statistics. If you then have a look at the firms that the makeup by reference to what sort of firms. Maybe next slide. The 10 largest firms, which by coincidence include the firms with more than 100 solicitors, they account for just under a fifth of solicitors with practicing certificates in the country. And this figure has steadily increased. I started collating statistics about the legal profession about 10 years ago. And if we'd gone back 10 years ago, we might have found that that was closer to 10% than to 20%. You'll see that the next 10 firms have just under 6%, and the next 10 have just under 3%. So approaching 30% of solicitors can be accounted for in the 30 largest firms. There are then a significant number of solicitors in smaller firms, firms with a single principal. That doesn't mean there are 2,175 sole practitioners, but it means that there are solicitors, assistant solicitors in firms with one principal, and they account for just under 2,200. And then there's about 5,000 in private practice in other firms of 2 partners or more. Now, the next statistic, which will be of interest for you today, is that at the most recent count, which is sort of errors and omissions aside, a figure that I got from the Law Society Regulation Department is that there are 1,350 in-house solicitors in Ireland. And this, as we'll see in a minute, is a surprisingly low figure of in-house solicitors holding practicing certificates. If we just go to the next slide, just other demography that is worth noting, that almost 2/3 of solicitors with practicing certificates are in Dublin City and County. The profession is majority female, and in-house is predominantly female. Interestingly, there are about 2,300 law firms in the country, and you contrast that with 1,100 firms in Scotland. And I think Scotland got into consolidation considerably ahead of Ireland. And I anticipate with mergers and so forth, particularly in the mid-sized firms, we'll see the number of actual firms reducing. And there are now 326 LLPs, which, and most of the large firms, including Mason Hayes & Curran, have been authorised as LLPs under the Legal Services Regulation Act. So the next slide shows the development of the gender breakdown. And you might wonder, why have I picked 1984 as my start year? Well, the reason is that's the earliest year for which there are readily available, reliable statistics. But you'll see that in the early 1980s, the number of female solicitors was about a quarter that of male solicitors, and steadily the gap has been narrowed, and now there is a majority female component of the profession. Just if you have a look at the last bit of that graph, you'll notice that there's a fall off in men holding practicing certificates, and that appears to be correlated to something we'll talk about in a minute, which is solicitors admitted as Brexit solicitors, we'll call them that, deciding not to renew their practicing certificates. And then there's a small cohort at the bottom where the Law Society is now collating statistics for those who don't wish to have a gender assigned to them. So the next slide will show the breakup of the breakdown of in-house PC holders. And you'll see that from a very narrow proportion back in the early 1980s, they grew in the teens, and then there was a fall off in the last couple of years. Now, while I was able to correlate the fall off in male holders of practicing certificates by reference to Brexit solicitors not renewing their practicing certificates. I don't think that that is the reason for the fall off in in-house solicitors. And the next slide has more accurate statistics. We might just leave that up there. You'll see that 10 years ago, there were just over 1,300 in-house solicitors with practicing certificates. And as of last week, there are just over 1,350 solicitors with practicing certificates. And there was a steady growth all the way up to 2017. And then each year since, from a high of almost 1,900, we're down to 1,350. So that's a significant fall off. So I might just leave that there for the moment.
Yeah, Paul, if I could just interject there, that looks like quite a fall off there from the whatever 1,800 odd back to the 1,350. Is there any reason that you can discern as to why or how that particular fall off came about?
I could speculate. I think that there might be an aspect of Brexit solicitors. In other words, solicitors who became, who were admitted to the role of solicitors, but then decided not to renew their practicing certificate. It may also be that a number of solicitors in in-house roles have formed the view that the nature of the work they do is not such as to require them to take out a practicing certificate. The jury is out on this. When I came across these statistics, I drew them to the attention of the relevant committees in the Law Society. And I said, have you any information on this? So they're actually going to conduct a survey to see where the missing 500 or so solicitors with practicing certificates have ended up. So, I mean, we can probably take down that slide at this stage and just get into a more general discussion. Neil, will you just outline for us when you do need a practicing certificate?
Sure, Paul. I think the reason you might be asking that question is that anecdotally we understand there may be some confusion about this, and possibly in the in-house area, and that's obviously of relevance to our audience today. By the way, when you and I refer to PC, we're talking about practicing certificates rather than necessarily referring to being politically correct, although I do hope we don't fall foul of that particular requirement. So we'll be talking about practicing certificates and PCs, meaning the same thing. But essentially, it's quite simple. If you're admitted as a solicitor in Ireland and you're on the roll and you want to practice as such in Ireland, whether you're in-house or external, you need a PC. This applies to everybody. That means all solicitors who are admitted and on the roll, except solicitors who are in the full-time service of the state and solicitors who are engaged full-time by an employer to provide conveyancing services for their employers, provided the employers are not themselves solicitors. Okay, because obviously you'd just be an employee within a law firm and would be required to take out a practicing certificate. So where does the law provide for all of this? Well, Section 46 of the 1954 Solicitors Act, that's the Principal Act, provides that the registrar shall issue certificates, referred to as practicing certificates, certifying that the solicitors named therein are entitled to practice as solicitors. So that's interesting. And there's reference to entitlement deriving from the issuing to you of a practicing certificate. Then Section 54 of the 1954 Act provides that only a solicitor whose name is on the roll, who isn't suspended from practice, who has a current practicing certificate, and who hasn't given undertaking to the High Court that he won't act as a solicitor, is what the Act refers to as a solicitor qualified to practice. So it's interesting that not only have we got references to entitlement to practice, we also have references to qualification to practice. So you're merely being on the roll does not make you a solicitor qualified to practice within the meaning of the Solicitors Act. So this notion of a solicitor qualified to practice is important because Section 55 of the 54 Act then goes on to say that a solicitor who isn't a solicitor qualified to practice must not act as a solicitor. So you don't hold a PC, you must not act as a solicitor. So note the difference between being admitted to the role of solicitor on the one hand, which makes you a solicitor, and being qualified and entitled to practice as a solicitor on the other hand, which makes you a solicitor who can lawfully practice as a solicitor. So only persons who are both admitted to practice and currently certified as entitled to practice are qualified to and can lawfully practice as solicitors and provide legal services. There's also a complementary provision in the Solicitors Amendment Act of 1994, Section 56. And this provides that, very clearly, no solicitor shall practice as a solicitor unless a practicing certificate in respect of him is in force. And all of this, everything that I've recited to you now, is reflected in the Solicitors Practicing Certificate Regulations of 2020. Article 3 of those regulations provides that every solicitor who is practicing or intending to practice or who is deemed to engage in the provision of legal services in the state shall be required to hold a practicing certificate. So you'll see that all of these provisions refer to acting as a solicitor or practicing as a solicitor or providing legal services. And I think they resolve themselves effectively into the same thing. If you provide legal services, whether as a sole practitioner, as a partner in a solicitor's practice, as an employee of a solicitor, or as probably most relevant again to today's audience, as an employee of any other person or body, then you are required to hold a practicing certificate and you're deemed to practice as a solicitor. And legal services are broadly defined in legislation as services of any services of a legal or financial nature that arise in a solicitor's practice. So it's quite a broadly defined thing, pretty much anything that a solicitor might do. And so just to sweep up then, to summarize, it's simple enough. Practicing certificates are certificates certifying an admitted solicitor's entitlement to actually provide legal services, whether in-house or out of house. And the possession of a practicing certificate, very simply, prevents you from breaching legislative prohibitions on A, practicing as a solicitor when not a solicitor qualified to practice, and B, practicing as a solicitor without a practicing certificate simply being in force.
The question I was going to ask there, because the state has given solicitors a monopoly in the conduct of litigation, instructing counsel, subject to exceptions, conveying real estate, agreements for the transfer of assets, drawing up of deeds, drawing up of wills. So, I mean, what's the situation if, for example, I don't do any of those items in respect of which solicitors are given the monopoly, maybe drafting terms and conditions for the provision of a particular service?
Yeah, I think you're referring there to the sort of reserved legal services. They're referred to as reserved legal services. As you say, the 1954 Act provided that certain services of a legal nature, like you've instanced, conveyancing, probate, litigation, effectively, those can only lawfully be provided by solicitors qualified to practice and not by other persons. So if you're an accountant or anybody else, whilst you might be quite adept at doing these things, you would be breaching the solicitor's legislation if you purported to try and provide those services. But the corollary then is that if you provide any services outside of the reserved area and you're an accountant, for example, you can lawfully carry out legal services in that zone. So there are lots of things that non-lawyers can lawfully do that look very much like what lawyers are doing. And you'll see that a lot of accountancy firms in particular provide services that are very much of a legal nature in relation to privacy and contractual matters and all kinds of things. Of course, they're not legal services. They are a legal service, but they're not provided qua lawyers or as lawyers. So therefore, they wouldn't, for example, benefit from legal professional privilege. But they may well, of course, be carried out in a very professional and high quality manner. But the point is that this has caused some confusion, I think. The fact that an accountant, for example, can carry out legal services in many areas without breaching the law has, I think, led some lawyers to believe, some solicitors to believe, that that must mean that a solicitor who is not currently authorized to practice with a PC may also do so. I suppose the theory here goes that it would seem logical that if you don't need to be a solicitor to provide an unreserved legal service, then surely an admitted solicitor may also do so without a practicing certificate. However, I think it does seem clear, and it is clear from the legislation, that if you're admitted as a solicitor and on the roll, you cannot provide any legal service of any kind, reserved or not, without a current valid practicing certificate being enforced. So don't worry about the reserved, unreserved, or don't start to think about the reserved or unreserved distinction in wondering whether a solicitor needs or doesn't need a practicing certificate. And I could just, if I just finish with this, that's importantly also the express view of the Law Society on its website and in its guides. So even if you don't buy that particular interpretation of the legislation, in practical terms, that's what the Law Society thinks. And that's the view that it and the Lsra will take of the matter.
Yeah, okay.
So Paul, if I could ask you a question, I noticed that you mentioned notaries in your introduction as sort of being part of the overall legal profession. What is their relevance in the in-house?
Well, apart from the fact that in-house lawyers very often, particularly for international companies, have need of a notary, in practice, not a lot, but it's there for completeness. There's an interesting point in that the profession of notary predates that of solicitor and barrister by many hundreds of years. And as a strict matter of law, they're entitled to carry out all the same functions as a solicitor can, with the exception of anything that is to do with litigation or the conduct of litigation. But in fact, very, very few practice in that capacity. And for in-house, I'm afraid, if you're a notary, you can't provide notarial services to your employer. You can only do it for external clients. So although being a notary gets you out of having to have a practicing certificate for doing an awful lot of legal work, tell us what happens if you don't have a practicing certificate?
Well, yeah,
legal services.
Sure. There are a number of consequences you can trace in the legislation that derive from a person not having a PC. Some of these relate more perhaps to practice as a solicitor outside of the in-house sphere, but they could potentially apply in-house as well, things like prohibitions on fee sharing with and between unqualified persons and purporting to act as a solicitor and so on. But I think for today's purposes and for all solicitors, whether they're in-house or external, the basic and important consequences are, I think, threefold. The first is that under Section 55 of the 1954 Solicitors Act, it's a criminal offence to act as a solicitor when not a solicitor qualified to practice. And we've seen that a solicitor qualified to practice is one who holds a practicing certificate. So if you don't hold one, you're committing a criminal offence if you're providing any legal service. I believe they're triable of indictment or summarily, but clearly either way, you don't want to be at the receiving end of a criminal prosecution. Secondly, Section 57 of the Solicitors Amendment Act of 1994 says that a solicitor who provides legal services without a practicing certificate is also guilty of misconduct. Now that's separate to the criminal offence, so it's misconduct to practice without a practicing certificate. And thirdly, as you mentioned earlier on, or as I think Declan might have mentioned in his introduction, legal professional privilege is clearly an important principle and an important benefit of engaging a legal advisor and obtaining legal advice or assistance with regard to litigation. And as we all know, confidential communications between client and legal advisor in either the advisory context or in the litigation context are privileged, provided they meet the other criteria of privilege. But I'm focusing here on the confidential communications between the lawyer and the client, and what kind of lawyer are we talking about? And the conventional expression of the legal professional privilege rule refers to the fact that the lawyer must be professionally qualified. And I suppose further that not only must he be professionally qualified, but also currently authorized to practice. And so again, there's that distinction potentially between being on the roll. Yes, you're professionally qualified. You're not an academic, for example, or a law student. You are professionally qualified, but are you currently authorized to practice? And I think that's important. So again, it is possible that communications between solicitors who don't hold PCs and their clients are not privileged. So apart altogether from being communications that solicitors ought not to be engaging in with their clients, given that if they don't hold a PC, they're committing an offence and also guilty of misconduct. The other consequence is that those communications may not be confidential and may therefore have to be disclosed in relevant context, say, for example, in litigation by way of discovery, or in regulatory investigations by way of information provision requirements. Yeah. So
can I just come in on one point there? Even if you have a practicing certificate, this isn't altogether to do with practicing certificates, but I'm aware of the fact that even if you have a practicing certificate and you're in-house, there are certain limits to the benefit of confidentiality stroke privilege when dealing with certain kinds of investigations. Is that not so?
Yes, that's so. I should have mentioned, of course, that it's unfortunately not an unlimited parallel, as it were, between in-house and external solicitors when it comes to legal professional privilege. And probably most people are aware of this, that owing to decisions of the Court of Justice of the European Union in cases like Axel Nobel, where, albeit in the UK and Ireland, I think in England and Wales probably the same as in Ireland, that in-house lawyers' communications with their clients are just as privileged as and confidential as communications between clients and external lawyers. The only exception being that that will not be recognised in the context of in-house solicitors where it comes to EU competition investigations. So when it comes to, for example, the Commission of the European Union conducting an investigation, whether by itself or with the assistance of the CCPC here, in-house lawyers' communications with their clients that would otherwise be privileged under our domestic law will not be considered to be privileged for the purposes of those investigations. So if there's anything of that nature, it's probably best to conduct those sorts of communications with your external solicitors.
Good.
Sorry, just a final thing, I suppose, that might be a consequence of not having or maintaining a practicing certificate, and I've come across this as slightly left field. Not having a practicing certificate might also affect your number of years of continuous practice as a solicitor. So say, for example, you might have an interest in future becoming appointed to the bench and becoming a judge. You need a certain number of years of practice as a solicitor, and you won't clock those up if you don't take out a practicing certificate from time to time or at all. So yeah, I've probably gone on about that. But Paul, can you give me a breakdown of, I mean, obviously we pay fees and quite hefty ones, I think, in terms of practicing certificates. But it might be of interest to the in-house community in particular, to know where that income goes in the Law Society. What does it go to? And in particular, can you explain about the compensation fund and if that has any relevance or comfort to in-house lawyers?
Well, yeah, we're going to have a Q&A after Neil and I have finished talking, but I think at this stage it's worthwhile. One of the first questions or remarks that has come in, which I'll read it aloud, The practicing certificates cost a crazy amount in Ireland. I'm qualified in New York, circa $250 every 2 years, and England and Wales, 350 sterling a year. The cost of an Irish cert is many multiples of this, and in my view, a potential barrier to entry. What's the Law Society doing to bring their fees more in line with other jurisdictions? Well, if I can say, first of all, I'm a member, if you like, of the Parliament rather than the executive of the Law Society. And certainly, this is unquestionably the case. It's about 2,500. I say about that. I mean, there is a precise sum, depending on what options you choose to pay for. But the breakdown of the 2,500 that one pays to the Law Society, about 40% of it goes towards the administration of the Law Society. There's a payment of, I'll just go down through them, they were given to me earlier today, 64 euros goes into a life policy, which pays out if you die while holding a practicing certificate. There's a litigation fund on account of the fact that the Law Society gets sued, well, historically in the past, judicial review and what have you, in relation to complaints. There's a capital reserve fund because it's a heritage building, and there may be no rental payment, but they have to keep it up every year. The Law Society pays towards, all solicitors pay towards their regulation, and about 1/8 of the practicing cert fee, anywhere between 250 and 300 a year, gets paid to the Legal Services Regulatory Authority. Then there's other options, membership subscription that I mentioned earlier, but the largest single item, which accounts for about 30% of the practicing certificate, is the compensation fund. And the compensation fund is fundamentally a bonding arrangement whereby if an individual, not a corporate, if an individual client of a solicitor suffers loss by reason of the bankruptcy or fraud of a solicitor, the compensation fund will pay money out to that individual client, subject to a limit of 750,000 euros per client. When I started practice, in fact, this was, there was no limit on the amount. And there was one famous case where I think the compensation fund was taken for over 2 million old Irish pounds. But fortunately, somebody had decided to take out disaster insurance, and the insurance, and to pay that up. But ever since then, just the nature of the client protected by it and the amount of protection that is provided has reduced. So the compensation fund now and again comes under focus, not just from in-house lawyers, but from large law firms, because candidly, I'm not aware of any claim on the compensation fund from any multi-partner firm. Now I'm talking, say, 3 or more partners. Having more partners brings its own sense of risk management. So the payments that have gone out to clients tended to be clients of sole firms, of sole practitioner or single principal firms. And, you know, we at Mason Hayes & Curran would say, well, what do we get for this? Because, you know, we're paying, you know, almost 300 times 700 euros into this fund each year. Well, if the compensation fund was not there, it would mean that for money transmission and retention in relation to property transactions, mergers and acquisitions deal, investment deals, administration of estates, litigation, what have you, we need to be authorized in some way under financial services regulation. So it probably it's probably worth it at the moment. I mean, we never like paying this amount. Interestingly, the actual amount of money that's paid out to defrauded clients of solicitors by the Compensation Fund is only somewhere between 10 and 20% of the money that's paid to the Compensation Fund. The rest of it goes on the supervision and accountants' visits to make sure that solicitors don't misappropriate money and that that they keep client money separate. But if I could just maybe again ahead of time say, what is the Law Society doing about this? Well, I think it started off an expenditure review last year, because it's not just in-house lawyers who think that the amount is a lot, because in England and Wales, if you're a practicing solicitor, the cost is about €1,000. And I think it's not much different in Northern Ireland. So that's being looked at. I think it's unavoidable that the Law Society is going to have to look at the objective fact that there was generally a belief that 1 in 5 solicitors in practice were working in-house. Even when you take into account solicitors in the full-time service of the state, I think there's somewhere between 300 and 400. That doesn't quite get you up to the 20%. So that certainly is a matter under review. So I think that issue will certainly run. Just going back to the practicing certificates, Neil, there was some controversy a few years ago about conditional certificates being issued to the Brexit cohort, if I could call them that. What was all that about?
Yeah, for many years, I suppose there had been, and particularly post-Brexit as well, an increase in the number of particularly English and Welsh qualified solicitors also taking out Irish qualification, being admitted to the role. And the practice had been for the Law Society to issue what appeared to be full practicing certificates to those persons, but in circumstances where they weren't actually intending to practice or practicing in Ireland. That assisted those solicitors in maintaining their continuity of practice here as an Irish solicitor, and also in demonstrating, importantly, an entitlement to practice as a lawyer in Ireland, which in turn can be relevant for establishing rights to practice abroad, and to enjoying rights of audience and practice, for example, before the Court of Justice of the European Union and other courts and bodies overseas. But a couple of years ago, the Law Society sort of went back to basics and considered that it had been overly generous in a way in providing what appeared on their face to be full practicing certificates in circumstances where the holder wasn't practicing in the state or intending to practice in the state. So what it did is it issued certificates to solicitors abroad that were expressed on their face to be conditional, and that said that they didn't in and of themselves currently authorize the solicitor to practice as a solicitor in Ireland. And that caused alarm on the part of the recipients, because suddenly they had a certificate which looked like it said, this person is not actually authorized to practice law in Ireland. But what the society said was, well, that's not what it really means. What it really means is you are not entitled without more to practice. You're entitled in principle to practice in Ireland. We're issuing you with a certificate that makes it clear that you're not currently authorized unless you come and practice here and unless you take out professional indemnity insurance. It also maintained that it had always issued sort of covering letters with those practicing certificates saying, even the full ones, saying, this is conditional on your actually practicing and actually taking out insurance. So as I say, it did cause alarm amongst the recipients who felt that now they wouldn't be able to demonstrate an entitlement to practice in Ireland, and that they would then not have those authorizations accepted by local bar associations or courts abroad as demonstrating an entitlement to practice here, with the knock-on effects for their rights of establishment or practice in other jurisdictions. But the society stuck to its guns, and the matter has since been resolved so far as it is now issuing these certificates of attestation that you mentioned earlier on. And they simply formally attest that the solicitor has been admitted to the role in Ireland, is authorised to practice as a solicitor in Ireland, subject to the provisions of the Solicitors Act and so on. And the purpose, the society says, is for registering with a foreign bar association. So it's not a practicing certificate. It doesn't permit the solicitor to provide legal services, but it makes it clear to any foreign audience of relevance that this person is actually somebody who is authorized in principle to practice here. The controversy also, I think, has resulted in a clarity and a very kind of well publicized policy, as well as legal position on the part of the society, saying that from now on it is not going to issue practicing certificates to anyone on the Irish roll who is not intending to or going to practice in Ireland in the forthcoming practice year. In that regard, I suppose, just on a practical note, if you're intending to practice in Ireland in the coming practice year, there's a sort of a strange timing about applying for a practicing certificate and then having one issued to you. Can you explain something about that?
Well, I can explain it, but I can't intellectualize it. The practicing certificates are generally applied for in the month of January and issued on the 1st of February. But they're issued with effect from the beginning of the calendar year. If you don't apply before the 1st of February, you end up having to apply in open court to the President of the High Court for, this is the case if you have practiced from the beginning of the year, and you, in those circumstances, you have to apply to the President of the High Court for a retrospective practicing certificate. So it's like retrospection up to 31st January, good. Retrospection after that, not good. But actually, we have a number of very interesting questions.
Sure.
We'll try and get to as many of them as possible. The first one, will slides be made available after the session? Yes, we'll get them out to whoever would like them. There was the next one, which was to do with the crazy cost of practicing certificates. Next, good point about solicitors in the full-time service of the state. Yes, they are practicing solicitors, but they, in fact, there are fewer, to say, than I expected to see on that list. I thought there were about 700 or 800. In fact, there appear to be fewer than 400. Now, they're the easy ones. Now, Neil, here's one for you. Can a foreign qualified lawyer give legal services just like an accountant, or is such a lawyer subject to the same rules as an Irish qualified solicitor?
Well, I suppose it might depend on the foreign qualification of the lawyer. That's something that clearly certain foreign qualified lawyers can register here and practice here. Clearly, if they're not authorized, I think they might be able to provide. So in other words, if they haven't maintained their home authorization and yet are not admitted here or don't have a practicing certificate here, it might be possible, this is a difficult one, for them to carry out services in the non-reserved. Yes, I think it's become clear in my mind now, because if you're an Irish, this is the point we were talking about earlier, it's kind of invidious. If you're admitted as a solicitor in Ireland, Irish legislation stops you performing any legal service.
Yeah.
But I think if you're not admitted as a solicitor in Ireland, well, then you're not subject to that prohibition. So if you're foreign qualified, you might be able to do non-reserved legal services without breaching the law. Position for barristers, yes, I don't think that prohibition applies. No, the prohibition doesn't apply to barristers. It's only non-solicitors. Has Brexit resulted in any change in this area? I'm not sure where that's going. Senior counsel, sorry, here's one for you, Paul, because you are a senior counsel. Very grateful for a short summary on the process for solicitors achieving the senior counsel. What are they called? Letters of...
So it's like a lot of things, you fill out a form and you describe your career, the books and articles and lectures that you've given, bodies that you've been a member of, And probably the most significant thing must be obtained is you must obtain a reference from a serving or retired judge and from one other legal practitioner. And the form is published on the Legal Services Regulatory Authority website. There have been 2 rounds of grants of patents of precedence, which is the technical expression that's used. And what happens is that once a year, there is a cohort who are appointed senior counsel. It's a government appointment, but it's delivered in the court. In my own case, it was last year, and it was done from my front room. It was all done virtually, but it was all done very nicely.
And there's a supplementary question to say, presumably that's open to in-house solicitors with a PC too, and I presume it is.
Beg pardon? Sorry,
there's a supplementary question in that saying, finally, presumably is open to in-house solicitors.
Absolutely. It's open to any practicing solicitor, and it's not a big firm thing. It's not a small firm thing. There's a full panorama of solicitors there in those who have been appointed. Now, here's one. What's the position of in-house solicitors as regards swearing affidavits and certifying documents as being true copies of originals?
Well, if you go by the jurat in your affidavit, it will say that the person taking the affidavit is either a commissioner for oaths or a practicing solicitor. So, as we know, to be a practicing solicitor, you have to have a practicing certificate. So, I presume if you're in-house and you have a PC, you can also swear. In fact, I know in practice that we do that quite a bit. We would, when we're having affidavits sworn, which we obviously can't do ourselves in-house, we would have to go to an external solicitor, and we would often go to in-house people as well as other firms of solicitors to find a relevant solicitor. So I think the answer is yes. If you have a practicing certificate, you're in-house, you can swear affidavits and so on.
This one for you, Neil. I think insurance is an issue. It's not available if you have no PC.
Yes, and I'm not entirely sure what the position is. I think in many instances or in certain conditions, if you're in-house, you don't need professional indemnity insurance. So it may not be an issue to you, but I don't think you would be able to get professional indemnity insurance if you didn't have a practicing certificate.
Yeah. Actually, there's an interesting one here, just building on the one we just answered, which is one of our people said, I raised a query with the Law Society about whether solicitors in the full-time service of the state could swear affidavits, and the Law Society's view is that they cannot, as they're not considered to be practicing solicitors. That's something I didn't know myself. So that's very helpful. Thank you very much for that. Can an in-house solicitor with a PC issue a summons, enter an appearance defense as solicitor on behalf of his or her employer, or is some form of authorization necessary?
I think the answer is yes. They're a practicing solicitor. Yeah, I don't actually know the answer to that, but I'm thinking, why wouldn't they? They're a practicing solicitor. They have one client, and they seem to have all the necessary ingredients for somebody who can do all of that kind of things. So I think the answer might be yes there.
So somebody is praising the Law Society here and saying it's helpful to note that the Law Society's in-house and public sector committee has pulled together some material on why a PC is necessary, which can be helpful for in-house solicitors to justify the cost to employers. So there's a link there, and what we might do is to send that link on after today's session, so you'll get it. I won't recite it aloud now. There's a question here about recapping the point about communications enjoying the status of privilege. Maybe, Neil, you could deal with that.
Sure. Obviously, communications between lawyer and client to benefit from privilege, whether on the legal advice limb side of the legal profession privilege rule or the litigation privilege limb, they both have to be confidential communications between lawyer and client. And so what is the lawyer? Who is the lawyer? What kind of lawyer are we talking about? And the lawyer, as far as I can see, has to be both someone who's professionally qualified in principle, but also someone who's currently authorized to practice and subject to the ethical and legal rules that apply to the profession. So in other words, that translates into being both admitted to the role of solicitors and holding a current valid practicing certificate. So you go on to say, could this mean in-house solicitors communicating with their colleagues on legal matters do not enjoy legal professional privilege? That's what I'm saying. If you don't hold a practicing certificate, you may not be deemed to be the lawyer that is required in the formula as to what is privileged. Lawyer-client, you have to be a lawyer, a practicing and authorized lawyer. And the second question, I think, is when is it recommended, stroke safer, to engage external solicitors so as to ensure legally privileged communications? I suppose that's a broad question. It potentially has a lot of aspects to it, but certainly from the point of view of the point that we discussed earlier on, that very clear point about competition investigations with an EU provenance or angle, if there is any prospect of that in the future or any current such investigation, in those circumstances, you'd be engaging in external solicitors, even if the internal lawyer is a PC holder, because at European level, they won't consider communications that we would consider privileged between in-house and in-house solicitors and clients to be privileged.
There's a question here. Two of the four lawyers based in the Dublin office of my company are barristers. Are there any specific regulatory obligations on them other than the requirement to register with the Lsra to ensure they benefit from privilege, etc.? I'm going to surmise the answer is yes, but actually I don't have the technical answer about the regulation of barristers.
Sorry, are there specific regulatory obligations on them? See, I think they are entitled, I'm not sure, I think the 2015 Legal Service Regulation Act, I'm not sure. I think it specifically provides for barristers in employment. I know that's been happening for a long time, but I think it specifically contemplates that barristers would be, as it were, not practicing the law library and would be employed as in this situation. There is a requirement to be on the, I think they call it the roll of barristers as well now, or there certainly is a register of practicing barristers that's maintained by the Lsra.
Yeah.
So I think, I'm not sure if there are any other obligations on them. For example, is the registration with the Lsra equivalent to our practicing certificate? I don't know if there's anything more they require, because I think in the past they would have had to be paid up current members of the law library, but clearly that's not something you would do if you were employed in-house. So there might be some little bit there to figure out at that end.
Now, I think we're coming close to the end of our slot here, but I just, there are three comments that have come in with regard to, because why is a compensation fund required if solicitors have PI insurance? The answer is insurers won't cover fraud or bankruptcy. How does the Law Society justify the well over 1,000 administration costs? Excellent question. I can't justify it. And there is this inquiry going on at the moment, and English practicing cert is approximately 400 to 500 per year. Irish PC seem extortionate. They certainly are disproportionately expensive.
Yeah, as you say, Paul, I think we are reaching the sort of 1 o'clock, and in fact, it just turned 1 o'clock. There are lots of questions here, and unfortunately, we haven't had time to get to them, but it shows great engagement. So thanks very much to everybody for sending those in.
Yes, indeed. So we might
come back to Declan.
Back to Declan.
Thank you.
Thank you very much, Paul and Neil. Sorry for making the basic mistake of speaking on mute there. That was very interesting. Paul, in your capacity as a member of the council, you've been extensively lobbied in relation to the cost of practicing certificates. It's a very good point. Very interesting, I think, to compare ourselves with the UK in that regard. And now for the second hour, we're very fortunate if we've had, I suppose, the advisor view. Now we have the captain of the ship. So we are really pleased to be joined by the Chief Executive Officer of the Legal Services Regulatory Authority, Mr. Brian Doherty. And Brian is going to take us through the regulatory landscape. You'll have seen some of the questions that have come through, some of which were answered, some of which weren't reached. and some of which, in fairness to Paul and Neil, they said they weren't entirely sure of. I don't know if Brian has all the answers. You don't necessarily have all the answers when you're the captain of the ship. You're just responsible for steering the ship, whether you have all the answers or not. But it's great actually to have the CEO with us and to get that kind of overview of what is the authority about, what are its functions, its purpose, and its priorities. We're very pleased to hear from Brian in that context. And the format of this presentation is Brian will speak for about 40 or 45 minutes and then take Q&A in the same way. You just put your questions into the chat function and Brian will answer them as best he can. And I'll come back in then just to help curate some of the questions. Don't forget, by the way, that tomorrow is the CPD Management Hour, and to balance our slate of all male speakers today, we'll have a slate of all female speakers on management tomorrow. But that's tomorrow. Now is the moment for Brian. So Brian, you're very welcome. You've got 660 participants waiting to hear from you. So take it away. Thank you.
Thank you so much. Declan, can you hear me okay?
Yeah, perfect.
Yeah, excellent. So thank you for the invitation. Delighted to be able to talk to you all about the work of the Lsra. And what I intend to cover is on the next slide. So over the next 40 minutes or so, and you'll see there's a lot to get through, but I hope to be able to highlight areas that are relevant to you as in-house counsel. I'm going to talk about the objectives and functions. I'm going to focus on the complaints process. And whilst in-house counsels receive relatively few complaints, it's not unheard of. And this same regulatory framework governs in-house lawyers and other barristers and solicitors. So should a complaint be made, or should you have cause to make a complaint, which is probably more common for in-house lawyers who we do receive complaints from in relation to other legal practitioners, it may be useful for you to know how the system works. And then I'll also touch on the other work of the Lsra and highlight some of those areas that impact directly upon you or impact upon the delivery of legal services and the legal services framework in which you work. And as you see, as I said, there's a lot in this. So this will be a bit of a whistle-stop tour. So starting with the Act itself, the Lsra. So on the next slide, it takes you to, this is the preamble to the 2015 Act. And the 2015 Act did a lot more than just establish the Lsra. It obviously established the Legal Practitioners Disciplinary Tribunal, which I'll talk about later on, and introduced new models. The framework for the new models of legal service delivery required the Lsra to establish the role of practicing barristers, and it also established the Office of Legal Cost Adjudicator. And I heard a question earlier on around patents of precedents, and it also introduced the framework for the reforms in relation to how senior counsels are appointed. So the 2015 Act is actually a significant act of reform and changed quite a few different areas, some of which fall within the remit of the authority and some of which are outside of that. So our statutory objectives then as a regulatory body are on the next slide. And you'll see, I always, whenever I talk about this, the statutory objectives in this slide in particular, this requires the Lsra to promote a balance, and that the objectives of the Lsra require it to be balanced in its approach, because you'll see that it speaks about protecting and promoting the public interest. It talks about protecting and promoting the interests of consumers in relation to the provision of legal services, but it also talks about promoting competition in the provision of legal services and encouraging an independent, strong and effective legal profession. Some people view regulators as being out to over-regulate, out to get those that they regulate, but that is not the case. Success for the Lsra is built upon us achieving and assisting, encouraging an independent, strong and effective legal profession. So that's how we're meant to, how we're set up, how we're meant to do what we do. The next slide, the key functions, the next 3 slides, take you across what the Lsra is meant to do. So on this slide, it talks about us reviewing and making recommendations to the Minister, and we can make recommendations in relation to the admission requirements of the professional bodies as listed, education and training, the professional codes and the organisation and provision of legal services in this state. And the next slide takes you through some of our other key functions, including disseminating information to the public in relation to education and accreditation requirements. We specify the nature and minimum levels of PII for barristers. We also, part 4 and 5 relates to the complaints function. So there's 2 parts. There's receiving and investigating complaints and also inspections. We maintain the role of practicing barristers, which I'll mention again later and hopefully cover the questions that arose in the previous section. We've also got a responsibility to promote public awareness, disseminate information to the public in respect of legal services, including the cost. And then the next slide covers through the remaining functions. So we have to keep the Minister informed of developments in respect of legal services, and you'll see at 10 there, we have a responsibility to undertake, commission or assist in research projects and activities in respect of provision of legal services, which may promote improvement in standards. And that actually is a huge amount of our work. And once I've finished talking through the complaints function and giving you some information on that, I touch on some of the research that we've done and some of the research that's ongoing and some of the reforms that are flowing from that research. So I'm going to focus then on the complaints function for about 20 minutes or so. It starts on the next slide. So Part 6 of the 2015 Act put the complaints function for both solicitors and barristers on a statutory footing. Prior to that, the majority of the process was for solicitors was on a statutory footing under the Solicitors Act, but not the same for practicing barristers. And it brings both sets of complaints under one heading for the first time. The focus of the Act, as I'll take you across, is focus on informal resolutions. It's solutions, not sanctions, is a popular term in relation to informal resolutions, and we look at things the same way. Introduces new time limits for some complaints. It establishes the Independent Legal Practitioners Disciplinary Tribunal, which sits outside of the Lsra, and requires a transparency, and which we use as a vehicle for informing legal practitioners as to the nature of complaints that are made and what are the complaint prone behaviours. And underpinning the Act itself, we've introduced 2 sets of regulations, one in relation to complaints procedures and the second to regulate advertising, which forms part of the suite of the regulatory documents. So the complaints themselves then, on the next slide. So there's 3 categories of complaint that can be made under the Act. Complaints of inadequate standard of service, complaints of seeking excessive costs or misconduct. And I'll go into that in a little bit more detail because I know a question has been asked and this has come up earlier on in the session. So there's a time limit of 3 years for complaints of inadequate services and excessive costs. There's a subjective element to that because it's 3 years for inadequate, either from when the service was delivered or from when the client knew or ought to have known that the service was inadequate. And there's a similar provision around excessive costs. There is no time limit for misconduct complaints, which may be of relevance. And a client of a legal practitioner can complain in relation to excessive costs and inadequate service, logically, but anyone can make a complaint about misconduct. And misconduct is defined over the next 2 slides. So you'll see it involves fraud or dishonesty, the delivery of services of an inadequate standard to a substantial degree. And I think this came up earlier on in the polls that were conducted, where you were asked whether you agreed or disagreed as to whether you should be regulated for activity outside of your legal practice. Well, in reality, that's already in place because under the misconduct, under Section 50, any act or omission occurring otherwise than in connection with provision of legal services that would justify a finding legal practitioner concerned is not a fit and proper person to engage in provision of legal services is already part of the misconduct definition. So as well as that, on the next slide, you'll see that any conduct likely to bring either the solicitor's or barrister's profession into disrepute can be complained of in relation to misconduct, and those complaints can be handled by the Lsra. I would also point out that where the Act consists of a commission of an arrestable offence, either within or without the state under J and K there, that's also one of the types of complaints that can meet the definition of misconduct and be handled by the Lsra. So the definition of misconduct is quite broad and was expanded in a number of different ways with the introduction of the 2015 Act. So those are the nature and the types of complaints that we can receive. And now I'll just take you on to what happens once we actually receive a complaint under the Act. So the first part is that there's a preliminary review and admissibility phase, and that sounds straightforward, but it's actually a form of investigation in the preliminary review phase. So once we receive a complaint, the Act mandates that we notify the legal practitioner concerned, and we include a copy of the complaint in any documents submitted. So back whenever I would be able to deliver CPD presentations in person, I would be minded usually at this point to ask the room whether they thought, or whether they would prefer to hear of every complaint made against them, or whether they would prefer to hear of only the complaints that were made admissible, so they would never be informed if a complaint was received and determined to be inadmissible by the Lsra. And generally there's a 50-50 split. Half the room would say they didn't want to know anything that wasn't really impact upon their practice, and the other half would say that if the client was dissatisfied, they wanted to know the reasons why, so they could deal with the complaint and address it. The notifications are mandatory, so in any case, irrespective of the nature of the complaint, if it meets the definition of a complaint under the Act, the legal practitioner is informed. We also provide information to the legal practitioner in relation to the process itself. We provide a booklet in relation to the categories of complaint, how complaints are processed, and we also refer the legal practitioner to any welfare resources that may be available. And that's in recognition of the fact that the receipt of any complaint can sometimes put stress on someone, is not a nice thing to have happen in any professional career. So once we've forwarded the notification to the legal practitioner at that point can engage with the Lsra and provide their observations on the complaint. And a sizable amount of complaints are closed at this stage as resolved. And significant numbers of legal practitioners, once they receive the complaint, if they find that there's something that they can deal with, either by provision of information or engaging with the complainant, they do so. And that's, in our view, that's quite healthy, that legal practitioners engage at that early point with both the Lsra and the complainant, and it leads to a proportionate response, and that complaints can be closed out early as resolved. And there's a number of occasions, actually quite frequently, we have to go back to the legal practitioner for further information. And once we've got the information and we have sufficient information to make a determination, we can determine that a complaint is either admissible or inadmissible, or where the complaint is the subject of civil or criminal proceedings, we can defer the determination of admissibility and inadmissibility until the outcome of those proceedings. So complaints being determined to be inadmissible, the grounds for those are just contained in the next slide. So complaints are inadmissible where they're considered to be frivolous or vexatious. And that's a term of legal art and effectively means that the complaint can't succeed in law. Sometimes people equate frivolous and vexatious with malicious, and that's not the case. It's the case or the complaint would not amount to any of the admissible grounds, or would not be a complaint that's permissible under the Act. Without substance or foundation is slightly different. So frivolous and vexatious means it can't succeed in law. Without substance or foundation means it can't succeed in fact. And that's what the best example of that is we receive complaints that say, for example, my solicitor did not provide me with a section 150 notice under the 2015 Act, so the notice setting out the costs. We provide that complaint to the legal practitioner, and the solicitor writes back to us, and in their submission to the Lsra includes a copy of the section 150 notice that was provided to the complainant. So in those cases, and I know that's very straightforward example, but in those cases, that type of complaint would be closed as being without foundation, because in fact it didn't happen. So the other ground for inadmissibility is where a complaint has been previously determined, and that's either by the Law Society or any of its tribunals, by the High Court, or it's been previously subject to civil or criminal proceedings and have been determined in favour of the solicitor. And there's equivalent sections under the Act for barristers. And we had anticipated that we would receive quite a number of complaints that had previously been determined because we were the new regulatory body in town, and that people would take the opportunity to remake old complaints. It has happened to a degree, but not in the numbers we suspect. Probably about 30 cases a year are determined to be inadmissible because they've previously been determined under the other existing regimes. And then cases can also be found to be inadmissible where they are outside the time limits that I've previously spoken about. So if a complaint is determined to be admissible, the next stages of the process are on the next slide. So the first thing is, for cases of excessive costs or inadequate service, or when it's a misconduct allegation, but the allegation relates to inadequate service of a substantial degree, the Lsra has to attempt to resolve the complaint by informal means. So in those three categories, excessive cost and inadequate service, and also in the one misconduct category, we have to approach the complainant and the legal practitioner and require their consent to attempt to resolve the matter informally. And we've trained a group of our staff in mediation, and we have some specialists who are informal resolution experts. Now, I would say that, well, there's two methodologies which we can use. The first is we can do it ourselves. We can offer the services of our own members of staff to attempt to resolve the matter, or we can find an external party. If we do it ourselves within the Lsra, then it's a free service for both the legal practitioner and the complainant. If we have to send it out to a third party, then the costs are split 50-50 unless there's an agreement reached between the parties. Now, I would say this is proving to be more difficult in practice than it is set out in the Act, obtaining the consent of both legal practitioners and clients at this stage in the process to agree to attempt to informally resolve a complaint, which may have been subject to several pieces of correspondence between the legal practitioner and the complainant before it even reached us, and sometimes positions can be slightly entrenched. We've gone back to this process to try and streamline it, to try and make it easier for both parties, as I said, because of the focus of the Act and reaching solutions on and sanctions. But if it comes to the point that we realise that a resolution of the matter is unlikely to be reached, then a notice is served on both parties, giving them notice that we intend to determine the matter ourselves in the authority, and giving them an opportunity to make any submissions they wish before we actually reach that determination. And any determination we reach can ultimately be reviewed by the review committee. So what that means in practice, so on the next slide, is that where a complaint's been made, it's been determined to be admissible, it's in one of those two categories, and we've not been able to informally resolve the matter between the parties, then it's assigned to a complaints and resolution officer to determine the complaint and make any directions that are appropriate in the case. And you'll see there that the powers that the complaints and resolution officers have to make directions. So under Section 66, they can make orders that would rectify the error made in an inadequate service complaint. They can also order that the legal practitioner pay compensation for financial or other loss. In excessive costs, they can direct the legal practitioner to refund, wholly or in part, the fees that were involved. They can also determine that there was no case to answer, that there is no need for a direction to be issued, and that the service delivered was not inadequate and the service delivered was not excessive. And so far, there have been directions in around just under 40 complaints where we've made directions, and directions can frequently be a combination of one or more of those powers under the Act. And as I said, those determinations and directions can be appealed to a review committee, which is just contained in the next slide. So the review committee is independent, established by the Lsra, but is independent in its decision making. And they review determinations under Section 60 or 61 alone. There is a misconception that they can review admissibility determinations, and we frequently get requests that the review committee review admissibility determinations, but there is no review process under the Act, and any complaints about admissibility determinations are actually made to the Ombudsman. So a request for a review committee to review a determination can be made by the complainants or legal practitioners, and then the review committee sits in committees of 3. And their powers, they can confirm the determination, they can actually give us the determination and direction back to the Lsra with directions that have been dealt with again, or that certain facts are established, or they themselves can issue direction under Section 66 or 61.6. So they have the same powers as the complaints and resolutions officer to deal with the complaints. And we've had the review committees sat and considered just under 6 reviews to date. And so far, it's I think 4 have been confirmed. 1 has been remitted back to the Lsra, and in 1 they issued a further direction under Section 66, where we had not issued a direction, and they issued a direction that the legal practitioner in a case pay compensation where we had found that compensation wasn't required. So that really, the review committee and the appeal to the High Court is the end of the process for inadequate service cases, or complaints of inadequate service, or complaints of excessive costs. On the next slide, I'm just going to take you through the complaints committee and their powers. So the complaints committee deals with complaints of misconduct. It doesn't make findings of misconduct. Those are reserved for the legal practitioner's disciplinary tribunal, which I'll talk about a little bit more in a second. But you'll see the complaints committee has nominations from both the Law Society and the Bar. It sits in divisional committees, and whenever a complaint is referred to us, the first thing it does is provide the papers back to the legal practitioner to respond to the complaint. Now, this is slightly different from the earlier process around admissibility, where we invite the legal practitioner to make submissions in relation to the complaint as to whether or not the complaint is admissible. At this stage, they're required to respond to the complaints actually made against them. And again, we would encourage that at this point, if any legal practitioners before the complaints committee, to engage early for reasons I'll clarify later on. There is an opportunity at this stage even to resolve complaints, and we do find a small number of complaints resolving at this point and being withdrawn before the committee, having an agreement being reached between the legal practitioner and the complainant. But the complaints committee also has powers to specify measures if they find that they're required, having considered the complaint. If they feel the complaint is out with the remit of the complaints committee, they then try it back to the Lsra for an application to be made to the LPDT. The measures that they can specify, there's 2 different types. On the next slide, it takes you through the directions they can impose, which do not require the consent of the legal practitioner. So the complaints committee, having considered the complaint, having investigated, and if they reach the conclusion that this is required, they can, and you'll see there, they can require the legal practitioner to complete a legal service. They can also require the legal practitioner attend a professional competency scheme, and then they have similar powers to waive or refund fees, apply with an undertaking. In cases of complaints that relate to the advertising of legal services, they can require that the legal practitioner withdraw or amend an advertisement, and they can direct costs to be paid to $5,000 to cost to the authority and also compensation to the complainant. I would also just highlight Measure 9 there, under Section 71(5)(I), and that is where a legal practitioner has refused, neglected, or failed to respond appropriately at all, or in a timely manner to requests from the Lsra in the investigation of the complaints, that the complaints committee can impose a fine. And that's one of the reasons why we think it's essential and very important that legal practitioners engage with the complaints process throughout, from the start of it, pre-admissibility, all the way to the complaints committee. Now, the measures that require the consent of the legal practitioner are on the next slide. So this is in effect built into the Act as what is in effect an early plea provision. So once the practitioner receives the notification of the complaint from the complaints committee, they can write to the complaints committee and accept the fact that the services were inadequate, or that the complaint has been alleged stands up, and they can, with consent, have the complaint determined in this manner, where they can consent to a sanction where the Law Society can impose a restriction condition on the practice certificate of the solicitor concerned, or in the case of a barrister, where they can ask for me to put a restriction or condition on the practitioner, the practice of the person as a barrister, by making an entry on the rule of practice of barristers to that effect. So again, that's the complaints committee process. The determinations are appealable to the High Court, and it takes to the end of the process within the Lsra and the Lsra managing the process. But where there's a complaint of misconduct that the complaints committee feel is outside of their remit and their ability under the Act to to deal with it, which is basically countered by the whether it's appropriate under the sanctions that are available to the complaints committee, where they can make a referral then to the LPDT, which is on the next slide. So this is the Legal Practitioner Disciplinary Tribunal. You'll see that's their new logo, which I seem to have kind of squished a little bit and putting it on the slide. So my apologies to you for that. So the LPDT, it's established. It's not established by the Lsra. It's established under the Act, and we provide it with logistical and administrative support. So in the same way as the Law Society would have had the Solicitors Tribunal, which is independent of the Law Society, and the LPDT is independent of the Lsra. We provide building and administrative support staff. And this feeds their costs of the LPDT ultimately feed into the levy and how the Lsra levies legal practitioners. It works very much as an ordinary tribunal. You'll see it has the power to take evidence and it's oral and public hearing unless that's contrary to the interests of justice. They have a range of sanctions which are contained under Section 82 of the Act, and they go all the way from advice and admonishment. They can award costs up to €15,000, and they can also apply to the High Court for restriction of practicing certificates or for a legal practitioner to be struck off. So the LPDT was established in November 2020. It's about to publish the regulations which will govern how it operates. And I said that they were completely independent of the Lsra in doing so. And it will receive applications that is hoped before the end of this year and hear its first cases early next year. So it's another significant part of the infrastructure around the complaints process that's being put into place following the 2015 Act. So on the next slide, just to mention the reporting that the Lsra is required. So I mentioned earlier on about the strong and independent legal profession and or objective to ensure that one exists. As part of that, the Lsra is required under Section 73 to report every 6 months in relation to the number and type of complaints it receives. We're specified that we have to explain the outcome of those complaints, the number of complaints dealt with by the Complaints Committee, and where a sanction has been imposed, the nature of the act or omission that led to sanction, and any measures and directions taken by the Complaints Committee. So we've reported on 4 occasions to date. So we were established on the 7th of October 2019. We were established on 7th of October 2019, and 6 months later, lockdown occurred on the day we were moving into our new premises. So it's been a challenging first 2 years, and you'll see there that we've received over 3,000 complaints in that time. So there's been a significant amount of activity, significant amount of work to do in both establishing these processes, refining the processes, and we've taken a reflective outlook in so doing. We're using the Section 73 report as a methodology of informing legal practitioners as to the type and nature of complaints that we get and what those complaint-prone behaviours are. So the themes that are emerging then are on the next slide. So the main theme that runs through nearly every complaint that we receive is around communication. Communication of the cost of legal services is a big issue. Communication of the risk of taking certain types of legal action and the time that things will take. I mentioned earlier resolution, and that has been a heartening theme in that legal practitioners, some legal practitioners are engaging early and attempting to resolve complaints where they can. We have a significant amount of complaints about probate. It's a recurring theme in our reports as to where probate causes difficulty. We get complaints from beneficiaries who are not clients of the legal practitioner who may be dealing with probate, and some of those cases are found to be inadmissible. We also receive complaints about conveyancing, and from a number of the banks, we received a significant number of complaints around solicitors failing to discharge undertakings. That, however, would be one of the areas where we see early engagement as being key, and a lot of the complaints about undertakings, I'm glad to say, are being dealt with in early course. We get complaints from barristers about non-payment of barristers' fees, and the Bar Library have taken in-house a service now that seeks payment of barristers' fees from solicitors, and one of the things that they do is make complaints to us whenever solicitors haven't engaged or haven't being able to discharge or having discharged barristers' fees. Engagement with the Lsra is we get it in both good and bad, and that we get that early engagement where we can get complaints dealt with and out of the way. And then in some cases, we have legal practitioners who effectively bury their head in the sand until such time as we're in the position where we're, because of non-engagement from the legal practitioner, we're at the position where we either make a direction or something's referred to the complaints committee. And at that late stage, the legal practitioner comes to us with options to informally resolve, which could have been done earlier in the whole process. And then just touching on complaints against in-house legal practitioners. So they are reasonably rare, very, very small numbers in relation to complaints against legal practitioners in-house. The issues that arise in them, one of the main themes is what capacity the in-house legal practitioner is working in at the time. Because as I said earlier on, only a client can make a complaint of inadequate service or excessive fees. Most in-house legal practitioners are bound by their own in-house HR procedures. So if there's an issue in relation to their own work, it's dealt with in-house and very rarely would make its way to the Legal Services Regulatory Authority. But there are cases where a legal practitioner working in-house is either involved in a decision-making process or involved in a decision that affects a third party and is communicated to that third party. And we have, in a very small number of cases, received complaints against that legal practitioner from an external third party. Now, in that case, it can't be excessive cost, it can't be inadequate service, it has to be considered under misconduct. And really, the only two avenues for that under misconduct are the two that I explained about whether it's conduct otherwise in the delivery of legal services. So if they're not delivering legal services, then it's external to that, or it's conduct that would bring the profession into disrepute. So it's a very, very narrow window. However, on the flip side of that, we do receive complaints from in-house counsel who are making complaints about external legal practitioners with which they've been involved, and frequently in relation to undertakings and some other very discrete areas, we see that in-house counsel have formulated and made a complaint and then manage the complaint process from their side through the Lsra. So it's not, as I said, it's uncommon, but it's not unheard of. So I'm going to take you through then, leaving the complaints, talk about some of the other areas of work of the Lsra and take you through a bit of a whistle-stop tour of these. So on the next slide, the Lsra is a significant statutory requirement to perform research. And some of these areas impact upon legal practitioners directly, and some of them just on the legal landscape in which they work. So you'll see there, we've had to do public consultation and reports in relation to legal partnerships, multidisciplinary practices, which I'll talk about more about at the end. And we've also had to do a public consultation and report on issues relating to barristers, including should barristers hold clients' money or should they receive instructions directly. On the next slide, let's finish these off. So recently, we've submitted a number of complaints, or some number of reports rather, following extensive public consultation in relation to the education and training of legal practitioners in the state. And those recommendations were to move towards a competency framework for the training of legal practitioners, and also for the introduction of a legal practitioners education and training committee, which would allow other providers to enter the education and training market and would also quality assure that training. Those recommendations were accepted by the Minister in our implementation stage, so that be reform that will be coming down the line. We have a responsibility to review the operation of the Act, and we're in that process again at the moment, and we do an annual report on the admission policies of legal professions. So those kind of reforms, introductions of new business models like LPs and MDPs, might have an impact upon you and your profession, and the reform of legal education and training. What is proposed will go all the way from the undergrad entry into professional education and ultimately to CPD. So a significant reform in those areas. And that's designed to try and ensure that professional education of lawyers is fit for purpose, fit for future purpose, and make sure that the lawyers we're getting can fulfill all the roles that the wide range of roles that lawyers undertake, including those of in-house. The next slide just sets out the 5 sets of regulations that we've introduced. And just for the interest of time, I just skip over that slide other than to say that these are the regulations that we have in place since we commenced. And just to talk about the role of practicing barristers on the next slide. So this was mentioned earlier on. This is the Lsra was required to establish the role of practicing barristers. And this is, it actually, in our view, and we've had this studies as well, it kind of expanded the definition of what a practicing barrister was in law. The definition under the Act is quite broad, but there seemed to be a perception. We kept meeting this as we were going out and establishing the practicing barristers. There seemed to be a perception that a practicing barrister was the wigged and gowned barristers attending court, but the rule is actually much, much more than that. I'd also point out that it's a criminal offence under the Act to provide legal services as a barrister if your name is not on the roll. So I've delivered this to a rooms of barristers in the past, and had seen a few people shuffling their seat as they realised that they had not yet fulfilled their obligation to come on the roll. But you see now on the next slide, the roll is well established, and the number is just under 3,000 on the roll itself. It's constantly evolving and updating, and there's a process in place by which people apply to be removed, and people update their details on the roll itself. But you'll see there that the number of non-law library practicing barristers is actually quite high, 748, and of those 249 in the full-time service of the state. Someone mentioned earlier on about the obligations on the practicing barristers. Well, they're obliged to be on the roll. As I said, it's a criminal offence if they're not, and they're also obliged to have professional indemnity insurance and to provide us with proof of that professional indemnity insurance once a year. Other than that, someone also mentioned Section 212, I believe, of the Act, which allows practicing barristers to provide legal services and represent their employer. Now, Section 212 is outside of the sections that establish the Lsra, and we've commented previously that that section seems to be slightly underwritten. There seems to be more required of it, and we made that comment in our Section 6 review of the Act. So that's the rule, and as I said, you can see it expands the definition of practicing barristers as previously held. The next two slides just cover limited liability partnerships. So the Lsra was tasked with the introduction of limited liability partnerships, legal partnerships, and the consideration of the introduction of multidisciplinary practices. So we've introduced LLPs, and we established the framework which allows existing partnerships of solicitors to apply to operate with limited liability. It's a permissive system. It's designed to be straightforward, and we introduced the framework, I think, 2 years ago under Section 130. And one thing that I know that in-house counsel have advised on, because I've engaged with in-house counsel in their consideration and advising legal firms as to whether they should apply for LLP status and how the application is done, and also any tax applications and any implications with the banks, which are both negligible. And we have we wrote an article for the Law Society Gazette on the impact of LLP status. There's also plenty of information on our website as to the process for obtaining authorization to operate as an LLP. And just on the next slide, it shows you the numbers on the LLP register, which is again available on our website. And we've about 350 LLPs we issued. Just to clarify, that doesn't mean we've rejected 136 applications. It means we provided application forms, and the firms then, having considered them, have applied and been authorised in 350 cases, including Mason, Hayes and Curran LLP, which I'm very pleased to say. So on the next slide then, I'm just going to talk about the levy, because I know this came up about the costs around the Law Society. So we are funded by a levy we issue a levy notice every year to the Law Society, to the Bar of Ireland, and then we issue individual levy notices on non-law library practicing barristers. So those that are not out with, or those that are not in the full-time service of the state, receive an individual notice from us every year. The levy is set up under Part 7. It's retrospective in nature, and you'll see there that the levy has grown then as the costs of the Lsra has grown year on year for the last 3 years, which we levied. We operate a very lean model of operation in the Lsra. We're always very conscious of the fact that the impact that regulatory costs can have on legal practitioners. We have to balance that with the delivery of the service, and there's that word balance again. But we have to balance that with the delivery of the service that we deliver in relation to consumers and also to legal practitioners. The levy itself can be quite problematic in its administration, and we have there are amendments to the levy model which flow from a review of the Act under Section 6 and the levy. We're hoping that the levy model is moved to a prospective and budgeted position from 2022, when hopefully the Courts and Civil Law Miscellaneous Provisions Bill gets enacted in law. And those amendments are very important to us. Okay, so the next thing, and I know this was subject to a question earlier on, so I'm delighted I included a slide on, is the patents of precedence. So this is the Advisory Committee and grants of patents of precedence. So the Lsra's role in this was under the Act, we established it, as the authority put together the Advisory Committee, the membership of which is outlined within the Act. So, and we then provide it with administrative and secretarial support. We've no hand, act, or part as an authority in the decision making of the Advisory Committee, although our chairperson is one of the members of the committee established under, as I said, under the Act. So we provide staff who put out the notice for applications. I think the next one will be out in December time for the third run of this. We assist with the administration of the form. We receive the applications. One person receives them and then provides them to the committee, who make all the decisions in relation to this themselves. And as you'll see, in 2021, 37 patents were granted. For all 37, it means they can use the title of senior counsel, and for the barristers that are granted, it means they're also called to the inner bar. And someone asked earlier on, can in-house counsel apply? They can, and if you have a look at the form that's there, you'll see that amongst the criteria includes that if you have a specialist knowledge of an area of law, is one of the things that you can prove that, or you can put evidence into to support your application to be senior counsel. So it's not restricted or limited solely to litigation. It opens the door for the last couple of years for in-house counsel, and obviously opens the door for solicitor senior counsel. I think there's been 27 in total over this year and last year, and that work will continue. So just talking on the next slide about some of our upcoming work. I mentioned legal partnerships there. So there's a quirk in the Act that meant we couldn't put legal partnerships into play until we get an amendment to Section 1. That amendment's included in the Miscellaneous Provisions Bill that I mentioned earlier on. So we're extremely hopeful that we'll be able to establish the framework for legal partnerships in 2022. And what that'll mean is that barristers and barristers can go into partnership together, and then solicitors and barristers can also go into partnership. So it opens up a new legal service delivery model. We're not sure yet of the demand or the uptake from it, although we have had some inquiries. I mentioned we're undertaking another review of the 2015 Act, which is required every 3 years of its operation, and gives us an opportunity, hopefully, to get some legislative amendments to some of the processes, which we think could be delivered more efficiently with some slight changes to the 2015 Act. We're currently, under the Act, conducting a consultation as to whether the profession of conveyancer should be, a sort of distinct profession of conveyancer should be introduced under the Act. I'd encourage you all to have a look at the website. The public consultation notice is up there. It closes out on the 6th of January. And obviously that would be a significant reform to legal services market if an individual profession of conveyancer was introduced. Excuse me. We've also been required by the Minister, we've been asked to submit a further report, which we're referring to as the barriers report, which is under Section 34 of the Act. The Minister can require the Lsra to undertake research on a topic related to legal services provision, and the Minister can outline the areas that they wish to have researched. And in this case, the Minister's asked us to look at what barriers may exist for either legal practice people entering the legal profession from different social strata or diversity issues, and also people maintaining a practice within maybe the first 7 years, as to any difficulties that might be for people having a barrister practice, solicitor's practice. And it's a wide-ranging piece of work. We're reporting to the Minister. We have to report to the Minister by the end of Q1 of next year. We just completed a lot of survey work in relation to this. Anyone who has an interest in this piece of work, if you look at our website again and our research functions email addresses there, if anyone would wish to reach out if they've got a particular experience, we'd be delighted to hear. hear from you. And this will allow us to make recommendations to the Minister as to maybe perhaps how the diversity amongst the profession could be increased and how some of the barriers that affect young or early career legal practitioners might be addressed. And then finally, for the purposes of the slides, although there is other work ongoing, just to mention multidisciplinary practices, because we've made a commitment that after legal partnerships are introduced, we'll go back and examine as to whether we should introduce to the market the concept of multidisciplinary practices. That is where legal services providers could go into partnership with, for example, accountants or architects to deliver a different and new type of legal services. And perhaps what's referred to sometimes as this one-stop shop concept of service. So thank you, folks. I hope my Northern Ireland accent and my propensity to talk quickly didn't make too much of that a blur. I hope some of it was relevant. And Declan will be happy to take any questions that have come in.
Well, thank you very much, Brian. I'd say you exhausted your glasses of water there. There's a huge amount of information there and conveyed in a really organized and tremendously helpful fashion. We do have a number of questions. Some are straightforward and some are, as is always the case, more pointed. And so we'll start off maybe with perhaps a more straightforward one. So if the Lsra is considering the admissibility of a complaint and they correspond with the complainant seeking clarification while doing so, is that correspondence brought to the attention of the solicitor against whom the complaint is being made?
Yes. So in line with fair procedures, we would tend to provide the information received to both parties. And that's outlined in the complaints form. Now, there is a point where in some complaints where it's necessary to go back 2 or 3 times whenever to both parties. And we know that can build up some frustration, but it does allow us the opportunity, if a complaint can be addressed in the pre-admissibility stage, to do so. But that can't be ever diminishing returns that we're going back and forth and back and forth. So there has to be a point where we have enough material to make the admissibility determination. And that's very important to know, that it's the information we seek is to allow us to make the decision on admissibility under the Act. And if it doesn't meet any of the admissibility requirements, well, then it moves on to the next stage where there are further opportunities for the legal practitioner to make submissions or for the complainant. So short answer, yes. Yeah.
Great, a very transparent procedure. Next question. There are a number of agencies / companies currently set up providing immigration and employment law services without being solicitors or legal practitioners. How is the Lsra currently approaching this issue?
Right, this is an excellent question. First, but though what you've raised aren't reserved services under the Solicitors Act, so it is permissible for non-qualified lawyers to set up advisory services of that capacity. What's not permissible is for them to put themselves forward as either barristers or solicitors. And in early course in the Lsra, I think it was even before we commenced taking complaints, we became aware of someone purporting to be part of a firm providing immigration advice who's putting themselves forward as a barrister. At that point, the criminal offence hadn't commenced under the Act, so we engaged with the Gardaí and provided them with assistance, engaged quite closely with them, and also because of the crossover in regulatory functions with the Law Society, to ensure that we could, and where we could prevent this activity, we did. The other thing we did was we started an information campaign, and we went as far as visiting immigration centres and putting up information posters around the provision of legal services, what's regulated, what's not, and warning those vulnerable people that were being exploited in these instances, where they should be going and what recourse they have. We still get complaints from about the provision of immigration advice that we do not regulate. They're unregulated entities, but they're not putting themselves forward as solicitors or barristers, and we regulate legal practitioners. So it's a tricky area, but we're doing what we can.
Yes, the key is they can do this so long as they don't purport to be solicitors or barristers, and then the informational component is to try and educate people looking for such services that they're better off dealing with qualified practitioners.
Yes.
Okay.
And we're still going to be pushing that information as things goes on. Something we go back to within our website and Twitter feed, that the safety of a regulated entity providing legal services.
Yes. Okay. Next question. Can a member of the public make a complaint against an in-house practitioner? I think the answer to that is yes.
Yes.
I.e., but I think the nuance here is where, i.e., they have an issue with the company, but no relationship with the persons they are complaining of. So it's more that they don't like the actions of the company who employs the solicitor as distinct from the solicitor themselves.
Yes, the Act, the 2015 Act, is based on the regulation of legal practitioners, so not, and the complaints function is against legal practitioners, not legal entities. But what we have found is that whenever we inform a legal practitioner of a complaint and say, this complaint has been made against you, that there's generally then a conversation within the entity, and we get a response back from the firm saying that complaint isn't against this person, that complaint should be against someone else within the firm, like a managing partner or someone who's taken responsibility for the actions of it. And we will then engage on that basis with that managing partner. Just to go back to the points made earlier on about the nature of the complaint that can be made. So if you had no relationship with this external third person who's making the complaint, well, if they're not a client, they can't make a complaint of excessive fees, they can't make a complaint of inadequate service. The complaint can only then be misconduct and has to match one of those, the narrower scope, as I outlined under Section 50, conduct otherwise in the provision of legal services, or behaviour that would bring the profession into disrepute. And I think that's part of the reason why there's so few complaints against in-house counsel, notwithstanding obviously the quality of service that can be delivered. What I'm saying is that they don't engage with they may not engage with the public as often, and therefore they may not be exposed to some of those levels of complaint, notwithstanding that the same regulatory framework exists for both in-house and external.
Yes. And if I may, my own observation is perhaps some more inventive complainants will complain against the solicitor saying it is misconduct to associate yourself with the conduct of your employer, which I disagree with. I don't know if that sort of thing has crossed the desk of the complaints department.
I'd say all human life is there. We've received complaints for, I worked in policing oversight for 17 years before I took this job. And the range and diversity of complaints that I've seen over the last 2 years has been, a revelation to me. The main theme around most of the complaints when they're dealing with the delivery of legal services is communication. That's nearly always at the crux of it. And then there are some complaints, like you've said, they're a bit more inventive and a bit more unique. But the process, we have to inform you of the complaint, and we just encourage everyone to engage at an early stage.
Very good. Another question, an interesting one. Brian, as regulator, any thoughts on actions against solicitors involved in insurance fraud? And if I interpret that question, perhaps we see reports of cases dismissed for staged accidents. In fact, there was one last week, and obviously the case has been handled by a firm of solicitors. It doesn't necessarily follow that the solicitor was in any way aware of the fraud, but what if you were forming a view that the solicitor might be aware of the fraud?
Well, it's a very tricky and fine area and we do receive complaints, and we receive complaints whenever a complaint's reported of, and a complaint has been dismissed. And bearing in mind that anyone can make a complaint of misconduct, so they do not have to be involved in the case. They don't need to be associated with it. Anyone who reads that report can make a complaint and say. Now, I know I'm mindful that there's guidance in the Solicitors Guidance Handbook, the conduct handbook provided by the law study, as to the level of checks that a solicitor should do in respect of receiving instructions from a client. The question as framed was if they're involved in insurance fraud. So quite clearly that would be criminal activity and misconduct. So it would be all over that. But sometimes whenever those cases happen, we engage with the solicitor, the legal practitioner, and say, look, this is what's been alleged. And the solicitor then sets out the limit of their instructions, what they knew going into the case and how the case then evolved at the court steps. Yeah. And sometimes that means that they've done their due diligence and that they were following the instructions of their client, which they were entitled to rely upon. In other cases, we've got to go back and probe a bit more and say, well, look, this is the evidence as we see it at this point. What steps did you take? But it's very topical, and it keeps coming up as an issue for us.
Okay, well, maybe we'll close with the one final question, which I suppose is an evaluative question. Should we be concerned about the high level of complaints received by the Lsra in its first 2 years? Or what should we feel?
Well, certainly the law said it had about 1,100 complaints a year coming up before the Lsra took over, and we're up about 1,500 at that point. But we have a different definition of complaint, different regulatory system in play. So it was always to be anticipated that we would have more complaints received, as well as that every regulatory body in its first couple of years, as they're in the new brand, the new body, receive a spike in complaints. So we were always predicted that this would occur. Where I'd start to worry is if year on year that seems to be the trend, especially whenever we're going to try attempt to reduce complaints by informing legal practitioners as to what the complaint-prone behaviour is. So I always say that every regulatory body, one of their ambitions should be to try and put themselves out of business by having an ever-decreasing level of complaint year on year, and we'll follow that same model. So hopefully to see those numbers come down as we're able to inform both legal practitioners and complainants as to the nature of the complaints that can be made and the nature of activity that attracts complaints.
Okay, we'll take one last question for very quickly. I just come in, right, just at the bottom of the list there. It says there are a number of inverted commas advisors, close inverted commas, to lay litigants who appear in proceedings in the superior courts as Mackenzie friends, or even not as Mackenzie friends, on a regular basis, and it is widely believed draft proceedings and receive remuneration for so doing. Generally, the proceedings they are involved in fail, and those they are, in inverted commas, assisting, close inverted commas, suffer as a result of their intervention. Is the Lsra looking at this or encouraging those who suffer from this bad advice to take action?
All remits stops at legal practitioners. Now, again, the same thing, we encourage that if you need the services, if you need legal services, go to someone who can provide legal services and are regulated to do so. That's the message that we would encourage. So if someone is not a solicitor or barrister in the role or on the register, they're out with our regulatory grasp.
Yeah, it's the same issue as in the area of question, really. All right, Brian, I really appreciate your time. It's very generous of you to give us a full hour, give us all of that overview. I hope our participants who stayed at north of 600 for most of the session, the full 2 hours, got value out of that. Really appreciate your time and engagement. Thanks again also to Paul and Neil for the earlier session, and hopefully we will see some of you tomorrow for the management session. So thank you very much.